Oh, stand for the pledge. Commissioner Atkinson, would you like to lead us in the pledge?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, all right. First item on the agenda is minutes for approval for September 24th, November 21st. Is there any corrections, deletions, changes to the minutes? Hearing none, is there a motion for approval?
Move to approve.
Second.
Move to approve the minutes of the 24th and the minutes of the 21st. All in favor say aye.
Aye.
Opposed? Carries unanimously. Great, we'll move to public comments, and we have two speakers. First speaker is Kim Rosenka. I did this by order of sign-up. So,
You know me, I can't come without papers.
Thank you.
Yeah, I think I got it. Are you good? I think it's something. Kind of terribly exciting.
Good morning, Chairman, members of the Value Adjustment Board. I've never been here before. This is new for me, so I may be out of order, and I apologize if I am. I am here on behalf of Chris and Sharon Williams, petition 2025-00078. This petition involved the denial of a transfer of homestead assessment difference from a previous homestead in Brevard County to save our home's portability. We had the hearing before the special magistrate on December 11th of 2025, and my client received the recommended decision of the special magistrate via email on December 16th, 2025, which is the first page of the document that you received. They also received it by mail. This, on page 2, when you look at it, says that this is a recommended decision. It's not a final decision, and highlighted on the bottom says that this will be considered before you all at a meeting, but there's no date set in there. We anticipated a notice of hearing since there was a blank on this document. We were never advised, neither I nor my client, or of the request for reconsideration process, or any link to any information about the reconsideration, nor would this have been understood since this board was to consider the decision of the magistrate. Even your notice for today, which is posted on the internet, says you're going to consider the decisions. There's nothing about a reconsideration or a rehearing or anything like that. I actually learned of this meeting on an internet search last week. Last year was in May. I assumed it would be in May. It's early this year, in my opinion. So we found out that way. It took me 4 days to even get the agenda, and there's no agenda material available to review at all. As I said, your notice says the board will consider whether to adopt the recommendations of the special magistrate. The hearing procedures under section 194.034 of the Florida statutes says the recommendations of the special magistrate shall be considered by the board. To me, as a lawyer, this is a failure of due process. My client was not properly noticed. You all have adopted some sort of recommendations for reconsideration, which I have page 4, 5, 6, 7. But I could find nothing where you adopted this by resolution. Where on the website, you have page 8, there's a resolution, page 9, there's a resolution. So again, I don't know that the reconsideration follows Florida law. I don't know that it was adopted properly. And I believe that this is a violation of due process, at least a violation of transparency, and it may even be a violation of the Florida Taxpayers' Bill of Rights under Florida Statute 213.015. I request on behalf of my clients that you provide a proper notice of consideration of their petition and the results from the special magistrate, and allow presentation on the recommendation of the special magistrate. I thank you for your time.
thank you. I think we should have our counsel respond to this. Ken.
Sure.
Said, Ken.
So Yes, sir. Yeah, I wasn't informed of this before Ms. Rozanka began speaking. This is obviously the public comment portion.
Right.
It hasn't been noticed as a hearing or anything adversarial. I would note, and I don't have a position on the substance of this since I haven't really reviewed it, but the agenda does provide that several requests for reconsideration are being considered today, 4 of them in fact. So, you know, that is on the agenda, just not this particular provision. The request for reconsideration local procedures have been available on the website for years. And obviously the board receives some each year. So I'm not negating what Ms. Rozanka said, but they have been available. They were adopted at a duly noticed meeting years ago. They may have, I think they may have been amended once or twice since then, but in any case, they've been up for a long time. So to the extent this is a request for the board to consider a request for reconsideration, my recommendation would be not to consider it for all those reasons. It's simply not, it's not before the board properly. And I mean, if we needed a specific reason among the others, the request for reconsideration procedures require a timely request. I believe it's either 10 or 15 days after the recommended decision is received. In any case, that was months ago.
Okay. So your recommendation is that we just don't consider it,
Take no action.
take no action.
May I respond?
Okay.
May I respond?
Sure.
Again, we're not asking it to be heard today. I'm just asking that you do a proper procedure where petitioners are noticed that there's a hearing and they're noticed of a request of this process, which to me violates Florida statutes. I'm sorry. It doesn't say anywhere in the Florida statutes about a reconsideration. It says you shall consider. It doesn't say you have a special reconsideration process. So with that, it's a transparency issue to me, and it's a lack of notice to my client. Again, you can't even get the agenda on the website. You can't even get the agenda material. And these are quasi-judicial proceedings, and these are evidentiary hearings. So to me, there's a problem with the process. And you know, whether we have a reconsideration or a petition, I've asked for another hearing where I can do a reconsideration where you can hear this petition. So that's, again, I didn't expect a result today. I just think there's a violation of due process here.
So now,
Well, what I was going to say, and you may have been saying something similar, the board actually will have for consideration today something relating to what Ms. Rozanka is asking for, which is, I would say, better notice of the reconsideration procedures. And to be clear, they're not provided for by statute. They're authorized by rule, but each VAB, it's up to them to adopt local procedures on requests for reconsideration or not. Some do, some don't. So there wouldn't be anything in the statutes about it, but something on your point is up for, or will be up for consideration today.
I wanted to say, if I may,
Yeah, please.
Chair, is it okay?
Yes, absolutely.
So we have a reconsideration today where we're revamping a lot of the notices, in particular to the similar sentiments that you had. If you can stay and come back when that happens, regardless of what happens here, right now, like later on, or if I could pick your brain right now if you have to go, on the process that you felt like we did not notice, so that we could add that to whatever we had today, if that makes sense.
I really can't stay, but I'm certain, I just think that there needs to be a better process.
Yep.
I mean, there's a blank on the sheet that should have been filled in.
So we can start there. So that's one of the items that you say, is that the date should be on top of that.
And there should be something on your form that says, please look at our website for the local rules. There should be some notice of these local rules.
Well taken. Yes, Commissioner Atkinson.
Having gone through this process, I agree with you 100%. The public needs to be, when it comes to this kind of stuff, we need to be babied a little bit better.
So let me ask you this. Besides putting the local rules on the website, besides putting the date on page 2 of your document, what other items could help notice?
The agenda could be published on the website and published sooner. I mean, the actual agenda, we had to call to get the agenda other than just the notice that's published.
Okay.
Publishing minutes would be helpful.
So as far as the process goes, those would be 2 points that we could bring up to improve the process for people who are making the recommendations.
Yes, sir.
Okay.
So we take no action here today because this is not an advertised hearing. Is there a provision by which we could allow this to come back to us in the formal process, or?
I guess what I would say is doing that would be inconsistent with the board's procedures.
Right,
So creating a single exception kind of breaks the rule. So
okay.
I would say the real answer is no.
Understood. But I had to ask.
Okay,
Thank you for your time.
okay, thank you.
Would you mind staying for my comments?
Sure.
If I'm next?
Okay, our next speaker, Dana Blinkley.
Obviously, I didn't know Ms. Rosenka was going to be here either, because she's not on the agenda. But I have my notes from last year when you guys adopted this procedure. And these were my notes from last year. This is an administrative nightmare. The new policy conflicts with 12D9.031 subparen 1 and 12D9.005 subparen 2, which I'm sure Ms. Rosenka is probably aware of. We have been on opposite sides of the table on valuation issues. She's very familiar with the 12D9. Number 2, nobody knows this policy exists. Number 3, it's not in action at the time that you file your petition. And 4, there's nothing on the DOR website or the forms that would lead somebody that has been through this process, an attorney, that would look for those types of forms for the DOR, because that doesn't exist. It's a local policy. Number 5 or 6, there's no magistrate or DOR training on this procedure, on exactly, which is a pretty lengthy policy that you guys adopted. And then there's a question of timing. So to that end, and I express my displeasure with it with some other reasons, which I'm going to go into here as well. But what I said to you is the property appraiser's threshold of whether or not a valuation is correct, or a classification or property is correct, or an exemption should be applied, or the standards set by law and the Constitution and the oversight agency. We have a long span of time that we try to do an information sharing with the property owner to make sure we have everything that we need, even when it's in dispute. But unfortunately, this process, just again, by virtue of what is required to even go through it, and we had a commissioner that filed, and she has every right to do that, because she disagreed with the value that the property appraiser had set. The process is difficult, and it's very arduous, and basically the legal standard for even meeting the requirements of a request for reconsideration are pretty stringent. And I'm going to read those to you, because I think it's very important, because I think some folks here today may even say that in order for me to qualify to even have my request for reconsideration meet the minimum criteria for which you would accept, you have to prove 5 things. First one's pretty easy. You can't include or reference evidence not offered at the hearing before the special magistrate. In other words, you can't present new evidence. But B, specifically identify erroneous findings of facts or conclusions of law, including, without limitation, how the recommended decision failed to comply with sections 194.301, 194.0342, 194.0351. And C, the next thing, identify the specific legal authority which such findings or conclusions of law violate. D, discuss why such finding or conclusion or violate or fail to comply with such legal authority. E, specifically identify relief requested by the requesting party, but the Value Adjustment Board is not limited to granting the relief itself. Responses shall address each of those issues raised in the corresponding request for reconsideration, and the Value Adjustment Board may find that the corresponding party concedes any issue with the responding party failing to address. Failure to comply with this section may result in the exclusion, sick part or all of the parties' briefs, because that was part. So again, and I think this is just a case, and I talked about it last year, of good initiative, but bad judgment. Bad judgment because these procedures already exist in law, and the threshold is already there for us to be met. And you hire an attorney that is supposed to make sure that any record of decision includes findings of facts or conclusions of law that are sufficient. They're legally sufficient. So once the magistrate that you hire hears that case, that registered state or general appraiser or attorney, once they hear that case and they supply the Value Adjustment Board, being the clerk to the board with their recommended decision, that is supposed to be reviewed by your attorney to ensure that it is complete and it meets these requirements. Now, 97% of the cases filed this year were filed by tax reps. They do this in 8, 9, 10 different counties. And so they're familiar with a lot of these statutes and evidence rules and exchanges and how those work. The 3% are the ones that I think most of you, and I can tell you, not that I treat any case any different, it's the same threshold, and I prepare the case in the same way. But I think we all agree that you have much more empathy when you're looking at laymen that are reading what is required to even meet the criteria. I doubt without legal representation that our commissioner sitting here today on this board could have met this threshold. And that is no disrespect to you. It's pretty arduous. And if you don't understand anything about the 12D9 and Florida statutes and all the Greenbelt laws and all the things that have to apply to make sure that you're meeting this threshold, probably you're going to have very small chance in that 3% to qualify. Now, you're going to find as we go forward in the agenda that we're going to have requests for reconsideration that are being considered here today that didn't meet these. And you're still going to be ruling on those. And I'm going to classify that as picking winners and losers. And I don't like it. I don't like it at all. I'm okay if I have a difference of opinion with another appraiser that is employed by you and we disagree on the value, okay? You might pay $10,000 more for a house than I would. It doesn't make my value wrong, it doesn't make yours wrong. The problem with this is it appears that it is insurmountable by our property owners to meet these thresholds. And now we have this additional process in place that is not needed, in my opinion. If the Value Adjustment Board attorney is doing what he's supposed to do and making sure that all of the records of decisions are compliant with law, then the only thing left is that the property appraiser still disagrees with the property owner or the property owner disagrees with the property appraiser and they take that to the next step. So I feel this is very unfair. I do not disagree with the attorneys standing before you today that this is not a fair process. And I do believe that it's inconsistent with law. And I did give you guys another legal opinion from my attorney last year indicating why he felt this policy was inconsistent with law. Now, it hasn't been challenged legally. Maybe it will be now. Okay. My goal is to always get the most information I can from property owners, from business owners, from folks that have leases for agricultural classification, to value the property correctly, to apply the exemptions correctly, and apply classifications correctly. This, I believe, is a violation of taxpayer rights. I'm not an officer of the court. I won't be testing that. But I will tell you that it makes me feel horrible for property owners because this is supposed to be where they can come and have an administrative right of appeal without having to hire attorneys. That's what we're supposed to be all be doing here. It's not about me winning or losing, but it's about a fair process and one that doesn't require an attorney. Going to the circuit court requires an attorney. We can all agree with that, but it shouldn't be for this process. So, thank you.
Okay, any questions? Any comments?
Have him respond a little bit?
Yeah.
There's no case.
Sure. So the local procedures on request for reconsideration are intended to be specific to put both parties, the petitioners and the property appraiser, on notice as to what's required. The process is essentially supplemental to the adversarial evidentiary process that precedes the board's consideration today. At this point, the parties have already had a full evidentiary hearing with an evidence exchange before a special magistrate. A recommendation is produced, and that's true, and I do review them for compliance, but that's for basic compliance. That's not, is it a perfect decision that all sides are going to agree with? That's not what I'm reviewing for. As for unfairness, I think the point there is being made is that it's too complex or too difficult for petitioners to understand without an attorney. Maybe because it cites statutes. I'm not sure. I guess the alternative would be to have it be less specific, more ambiguous. But the purpose of the procedure is to ensure, it's a balance, and there's always a tension. On the one hand, do you want to have more requests and a looser standard, or do you want to limit it to issues where one side or the other can identify a specific issue based on the facts and the law that they can cite that the board wants to take a closer look at? And that's really what the purpose of a request for reconsideration is. It's not to reweigh evidence. It's not to have a second hearing. It's not just to have the board look at what the magistrate did, though the board can always do that at any point on any case and raise issues with if they think there's some problem with the recommendation or with the hearing or anything. So this process is not intended to apply to the vast majority of the cases. By its nature, it is really intended only for it'll ultimately be a relatively small number. So I'm always open to improvements for the local procedures if any are being proposed or suggested. And I absolutely agree that we could probably do a better job of letting the public know about the existence and procedures for the process. But they've been on the website for years. And I would say many other VABs have the same or a very similar process in place. Really, the process as it is, you could tweak it, but there's not a whole lot you could do to change it. Fundamentally, both sides get a chance to submit written briefs. I look at it, offer an opinion, and then it comes before the board. That's the process in a nutshell, and the particulars could be tweaked, but that's really the only way the process could exist. And again, it's not something provided for explicitly by statute, though the DOR has made clear that it believes that requests for reconsideration can be adjudicated by the board. And while I can't recall whether these specific procedures or ones substantially similar have been approved by DOR, I know there have been a few attacks on similar procedures over the years and none have been sustained. So I don't want to be too specific or speak for DOR or anything like that. But the general parameters of the procedures really can't be changed too much because they just describe an adversarial process that reviews the underlying evidentiary process and evidentiary hearing. So there could be tweaks, but probably not wholesale changes unless the board wanted to do away with the process altogether.
May I respond, Chair?
Briefly, yes.
I was successful on every request for reconsideration except for one. On every one of them. So if any of the property owners went and got attorneys to prepare their request for reconsideration, they ended up with the same exact result. Except for one. And the one that the attorney disagreed with me on, the magistrate approved the act. So the result is the property owner's going to get the act. But I prevailed on every one of them.
What were the numbers? How many were there total?
Total cases that had
Yeah,
a
one
hearing.
out of how many?
I'm sorry, Commissioner, how many had requests for reconsideration or how many cases went before
You
the?
said you won except for one. How many did you win? How many did you lose?
Maybe 10,
10.
maybe 10. The clerk would have to tell you, maybe 10.
Okay. Okay. Any other questions or comments?
Thank you.
Thank you. Thank you for your input. Thank you for being here. Appreciate it. Okay. I think we should move on to the agenda. All right, new business. Okay, public comments, proof of notice meeting posted. Clerk, did you get? I see that on the agenda. Do we need to just acknowledge that? All right, request for reconsideration on the following petitions, 3 minutes per speaker. First petition is 2025-0095. Are they here?
I don't know what the number means.
I mean, I'm here for something, I just don't know the number.
F1 looks like it is Watermill? Yeah, Watermill.
Are they here? Will you guys be present?
I believe that the property appraiser you put in for the request for reconsideration on this one.
Correct.
You put in for it.
Correct, so I just wasn't sure if you wanted them to go first or me to go first. On this case, I'm not here to argue the contents of my request for reconsideration. I went through all of the criteria established, made citations on the statutes that I felt were appropriate, that were not discussed in the findings of facts and conclusions of law. I'm going to agree to disagree with your attorney on this, but this is a case, it's been quite interesting, this piece of property. It's been a case of the tail wagging the dog for several years. So we've had a piece of property, and I know folks in the county are very familiar with it. We had governmental agencies that are very upset with the property appraiser because the owner has applied for ag and met the criteria to receive ag. And then we've had, which has made the neighbors and code enforcement in the county angry. And because there's been some activities on the property that didn't meet other tests of law. And then subsequently, when I disapproved ag because they don't meet the ownership and use as of January 1, they come to this board and have received ag in the past with no lease. They've received ag in the past without allowing me onto the property. So just understand, here we are the third year in a row, and the county is out there and code enforcement is citing them for doing stuff, and the stakeholders that want this property to have ag and don't want this property to have ag are equal forces out there. So doesn't matter to me. Again, my threshold and standards are the law, the Constitution, and the DOR when they review the cases. No lease, no receipts, no Schedule Fs, no ag. You don't allow me on the property, I can't inspect it. Those types of things. So I expect we'll be back here in 2026 because they've yet to file, waiting to see what you're going to do with this. That's going to be interesting because there were no cows and no leases and no cattle and no tilapia harvesting on January 1, 2025. Certainly it isn't there on January 2026, and we have no application as we sit here today. So this is going to go through as is. And I guess I'll see you back 2026.
I think that's what I wanted to speak about.
I'm sorry?
That's it. I'm just a normal person. I don't really know what the procedure is, but it sounds like this is what I came here to speak on. So if I may.
Yeah, absolutely.
Okay,
You go sit over there so we can get you.
sure.
Thank you.
Now, I may not be speaking on the right subject.
You're not.
Okay, well,
One of those days.
there is a property in question in Malabar. At the border of Malabar is Palm Bay.
This isn't.
I don't
know
think this is
that
the
there's
right
property-
case.
This is Merritt Island.
No, this is,
This one's Merritt Island.
I'll wait until we get to the Palm Bay Malabar.
Okay, good.
Right,
All right, that's good. Better early than late.
yeah.
Okay, any questions in relation to this denial?
For me.
Okay. So do we need to take a formal action of agreeing with the denial, or we just?
So this case, the recommendation was actually to grant the agricultural classification. The property appraiser has asked the board to reconsider that grant and is asking for the agricultural classification to be denied. My recommendation was to deny the request for reconsideration. However, the fact that the petitioner isn't here, the board can consider that. There's no specific rule that weighs on that, but
Consider what?
it's the lack of the presence of the
Right, okay.
petitioner today.
So the application is not here. Property appraiser recommends denial. The special master recommended approval.
Recommended, yes, approving, granting the petition for the agricultural.
Okay. That's a classic case. We have a decision to make here, and I turn it over to the board.
So I would say I'm obviously a bit torn because petitioner's not here, but then I wonder, did he miss the process? Did, you know, and that's what, you know, we're gonna talk about. So for me, it's difficult to say, well, he's not here, so he doesn't care, or however I might use that to base my judgment on, so.
Just for the board's clarity, the
Yeah.
petitioners or the parties here for the request for reconsideration are specifically notified of today's hearing.
How do we notify them?
Right.
There's no other way to do it. I agree with you. I think, you know, what we're looking at is, we have a problem with portions of notifications. It's on us, we're trying to fix that. Lady comes in and says that she has problems on it. Now this person doesn't show up, not that they did that
Not
because of
saying,
that,
right.
because it sounds like there's some issues that are going on outside of the scope that are there. No, I agree with you. Know where your direction is going. I do. What do you guys want to do?
Well, it's up to us. A motion either for the denial or agreeing with the special master would be in order.
To the extent it may help clarify, just to play out what the board's decision would lead to either way. If the board grants the request, that would mean it goes back to the special magistrate for essentially either a new hearing or to revise the recommended decision in some way, presumably to deny the request in whole or in part. If the board votes to deny the property appraiser's request, then essentially the board would be approving later in the meeting the recommended decision without change.
Okay. Well, it sounds like we're a little bit of an impasse. Is it proper for us to move on to the next case and come back to this one?
Sure.
Maybe they want to read some more of the documentation we have. So let's move on to the next one, 2025-01295. I'm scrolling down.
1297,
Is that, I'm sorry.
yeah.
2025-01297. That's our next case. It's on page 40. And that would be Stephen R. Reed, Revocable Trust. Is there anyone here representing Stephen R. Reed? Okay, I don't see them. Do you want to give us a briefing?
Sure. This is the petitioner's request. They're asking for reconsideration regarding the valuation. I believe this was a condo in Cocoa Beach. I recommended denying the request, being that the party making the request is not present. I would recommend denying it.
Okay. Any comments or questions or motion?
So they made the request to come before us, and they didn't show up.
Correct.
Do we have phone numbers for these people?
Can somebody tell me what the
Not
difference,
that I'm saying that we should call them. I'm just.
Yeah, absolutely. Okay. Commissioner Atkinson has a question?
can somebody just give me the bones of this thing? So what was their original valuation? What did they get? value too.
Yeah, the original valuation was 1.173 million. And they were asking for a reduction in value. The magistrate recommended denying the request.
Based on,
The petitioner's primary argument on reconsideration, I guess I would say they object to some consideration of post-January 1 sales, which sort of as a general, I don't know if rules the right word, maybe guideline, it's generally improper to consider sales after the lien date of January 1. But that's not really what happened here. It was a sale of the subject unit, I believe, maybe June, so about 6 months after the lien date. And that wasn't used as a comparable sale per se. It was more used just to track whether there's, a trend toward lowering values, and that was not the case. But the decision or the recommendation was still based on essentially the property appraiser's comparable sales. I thought it was a well-supported opinion. The fact that the sale of the subject unit was considered in a limited way, I think there was nothing wrong with that. It's not a per se rule that you can't get, that it has no evidentiary value. It just shouldn't be, the sole basis certainly for a decision, but it was based to track the trend, which the petitioner was arguing was a downward trend, but that the sale of the unit itself really negated that.
well, I was just gonna say that if it's sold, that's what it's worth, what somebody's gonna buy.
6 months later, so again, it wouldn't be proper to base the holding solely or explicitly on that, but to note the trend is certainly proper.
See, I would support this because if we could now have the hindsight of looking at the sale, and so we kind of know that this is probably accurate.
That's fair.
That's my thought.
So that would be a basis to deny the request.
So I'd like to make a motion to deny the request.
Motion to deny, is there a second?
Second.
Second, any debate? All in favor of the motion, signify by saying aye. Aye. Carries unanimously. Next item is 2025-00791. That is on page 73 of our packet. And petitioner's name is Mark Krasnow. And is there anyone here representing the petitioner?
This was a petition appealing denial of a late filed agricultural classification application. He filed late. The special magistrate reviewed the circumstances. The same person or owner had essentially done the same thing last year, filed late. VAB denied that petition in '24, and based on, among other that, but also the specific facts in this situation, the magistrate recommended denying the petition.
Okay,
And so if the board wanted to prove that and not permit the late filed application, it would be a vote, a motion to deny the request.
absolutely.
So-
Commissioner Atkinson has a question.
So the petitioner has a history, at least before, of paying late?
Of filing their application late, yes. At least
And
going back 1 year.
it happens the same time every year?
The deadline is the same each year, yes.
Then I would make a motion to deny based on the fact that the petitioner has already gone through this once and should be aware of the dates. That's always the same.
Okay, there's a motion for denial. Is there a second? Second. Any discussion, debate, questions? All in favor of the motion, signify by saying aye.
Aye.
Opposed? Motion carries unanimously. Okay, we will go to 2025-01334, and that's Kalina Ratland.
I guess I need to give an overview of the petition. So, my late husband and I purchased the property in question in 2014 and had homestead exemption on the property. We, in 2020, had a marital situation and were separated, and I purchased another home and filed for homestead exemption, porting my homestead to that other property. We were living completely separate, and we were, you know, again, marital issues. Applied for homestead exemption. In 2021 was whenever I purchased that home. In 2023, I sold that home and moved back into the residence in question that we had owned together. My name never came off of the deed. My husband had been diagnosed with stage 4 cancer. I moved back into the home, working full-time, raising 2 children, taking care of my husband that was dying. I had no knowledge that I needed to notify the property appraiser's office that I had moved back into the home. I changed my driver's license, filed our income tax together, everything. I just had no knowledge that I needed to notify them. When my husband died in 2024, I went into the property appraiser's office to remove his veteran's exemption and file for my widow's exemption. I did not realize that that was going to trigger my cap to be removed because I did not notify them prior to my husband dying. So when I got my notice, my tax bill, of course, my assessed value had gone up because my cap had been removed. My homestead was still on there, and I went back to the property appraiser's office. They helped me with porting my homestead exemption back, but that did not reestablish the cap on the home. So my argument to that, I've gone through the hearing process. The magistrate ruled in favor of the property appraiser's office. I'm not questioning the fact that Honorable Blickley, followed the procedures, and I think there's a spot in the rule, though, that does not cover when someone died and I have no way to now go back and correct the fact that I didn't notify them. If my husband was still alive, obviously I could do that. We could go in together and have made that application again. My cap would have stayed in place. My property taxes would still be what they were last year. But the fact that my husband died, and I can't change that, obviously, seems like a very big flaw in the system, and I know it applies to probably a very small number of people that fall into this situation, but nonetheless, it has happened to me. I'm in jeopardy of losing my home now because I can't afford my mortgage that went up $900 because of my property taxes that increased on home again that's been in my name since 2014. So I'm, I guess, looking for the board's discretion to reconsider that and realize that I've provided ample proof that I moved back into the home. I had sold the other home. It's not like I was benefiting from 2 homestead exemptions. I wasn't playing the system or taking advantage of anything. I just did not know that I needed to notify them that I moved back into the home. The home had homestead exemption on it, still did. Never in a million years would I have thought it would have triggered any change. I've worked for the tax collector's office for 35 years, and I didn't know this, so there is no way the general public would have knowledge of that either.
Absolutely.
Can you tell me financially what it looks like, what you were paying and what you are paying now?
So my mortgage before was $2,400 a month, and it's gone to $3,400 a month.
Right.
Of course, part of that is my homeowner's insurance went up some, but my property taxes went from $4,600 a year to $10,000.
That was my question.
And then now with my portability applied back, it's at like $8,600 a year. So it went up $4,000 a year. And then, of course, my value going up, my increase can go up even more now every year because my 3% cap is based on a higher value than it was previously.
And I very much understand what you're talking about. And so my issue, again, is not that the process that the property appraiser is following was done incorrectly, but that how things are getting, the unusual things.
Right.
I have a problem with how the property appraiser is told to value our properties, number one. In your situation, I agree with you. People don't know that they have to do that.
No.
Ms. Buckley, can you tell us how many cases like this come before you a year? Is this like a diamond in the rough, a needle in a haystack, or is this something that comes where because they petition after and they don't know and everything else, is this a...
I can't quantify with Kelly's situation, and please know this has been a horrible situation for both her and the property appraiser's office.
I understand.
It's just a case where I can't violate the Constitution in order to grant a homestead. Kelly's is very rare because her husband passed. So typically what happens with married but filing separate is there's not a reunification. And if there is, many times properties are sold, but I have to say, and I've realized that going through your husband's death is, other than child, is maybe the most horrific thing you do. But when you come to the property appraiser's office and you are married and you file married but separate, it's the most invasive process that there is that we have to administer. So we make you aware at that time, we make you prove that you have no intermingling of finances, that you're not beneficiaries on insurance. I mean, it's a terrible, we have to ask you and you have to prove to us your marriage is not intact. Okay, I would love to get away from the married but separate. So, but once you do that, you sever your cap and your rights to your cap, because once you file homestead on a new property, now you're establishing a cap. So you can't have homestead or a cap on more than one property. So the best that we could do, when Kelly's husband died, he lost his cap. She didn't have a cap on that property. She had a cap on the property that she had purchased and subsequently sold, and we were able to port, because she met the time requirement to port. You can go without homestead for 2 tax years. You have to, in a place to file and own and occupy for January 1 of the following year. We were able to port her portability to that property to reduce her assessed value legally at that point, but there was no way for me to keep her husband's cap in place. I can't legally do that, so, you know, we do our best. All of you that own property, you know that we have a section on there, so we have life event changes, you know, if you get married, make any changes to your title or what have you. You know, we do our best to be as proactive as we can, and we certainly are very thorough on the married but filing separately. That's when we let folks know. Now, that means you have no rights, you have no cap, you have no benefit to this property for homestead purposes, even though your name's on the title, because you've established it on this property.
So Dana, I have a question for you. So if we vote in favor of Mrs. Grantland, will you be suing the board?
No, I would have to sue her.
I got a question. Yes. I have, go ahead. You first. I noticed in the recommendation from our general counsel, you recommend the board deny the request for reconsideration. Is that, at this point in time, we don't vote on the petition or not, we vote whether we're going to reconsider it. Is that correct?
Before the board is whether to essentially grant the petition.
Right now.
Essentially, yes.
Okay.
Essentially. I mean, that's what
Okay, I
it
just
would
want to
come
be sure, because the way that's worded, it sounds like we're voting on the reconsideration or not.
It's framed as a request for reconsideration, but if the board were to grant it, then practically speaking, that would be granting the petition.
Would we need to go back at the end of the meeting and
There'd
vote
be-
again?
There would have to be an
Another
additional
vote.
board meeting following revision, at least of the recommended decision by the special
Right,
magistrate.
right. So this would not be final. If we voted to accept her request, this would not be a final.
Correct.
We'd have to have another meeting. Okay. I
Can I
just
add
wanted to
just a
clarify
couple more
that.
things too?
Absolutely.
So speaking to what Ms. Wickley was saying, a couple of other situations that could have happened, and like she said, it's a very invasive process that I had to go through to get the homestead. But whenever I sold the home, of course, you're not going through that process again when those things are relevant to inform you of what that really means now. And I, again, did not know that I needed to notify them that I had moved back into the home. If I had done that, this would be a moot point. The cap would have remained if I had just gone in and notified them. So the fact that I've proven that I did live back in the home before my husband died also seems like it should be able to be considered. The other thing, had my husband and I divorced whenever we separated and remarried, I would have been eligible for his cap to have gone back in place. If we had divorced and my husband remarried someone else, they also would have been eligible for his cap to have assumed it as his new spouse. So it does not seem in any way right, or the intent that the law would be for me to be penalized for the fact that we did not divorce and were able to rectify, our marital differences and moved back in together just by the fact that I didn't know that I needed to notify the property appraiser's office. I mean, there's all these other situations that would have been eligible to have assumed that cap, but I can't,
Can I ask a couple questions?
Please.
I'm sorry you have to
Yeah.
do this whole thing.
If I may, I have a question specific to what you just mentioned. Because I was going to bring up that very point, because of reading our attorney's review of the case. It points out, when the petitioner returned to the subject property in 2023, she did not notify the PAO office or take steps to reestablish her homestead prior to her husband's death. And section 192.011, parentheses 10, for our statutes requires property owner to notify the property appraiser. So the statute does provide for a process that you notify the property appraiser. And the record supports the conclusion that this requirement was not satisfied. So this is the statute provides for you to receive your homestead, to get it back when you move back. The intent was to provide you to get that. What this really boils down to is just a lack of not knowing that statute and notifying the property appraiser. I don't know what the statutory, maybe that was an informative thing. To me, that's a very small technicality. That the intent to follow the law was there. It was a technicality that I think the statute really didn't foresee. And I don't know, that's just my general feeling in this matter.
Chair, while I'm very interested in your attorney's response to that,
I really wasn't looking for a response in particular. I just was sharing my feeling that the way the statute's structured is providing for a process for her to do the very thing that she did.
Yes,
Just
sir.
there was a technicality she missed.
But the board cannot grant an exemption in absence of an application, nor can I. In this case, I had no application for exemption. So I would be violating the law, sir, and so would this board, and so would the magistrate if they would have approved an exemption in the absence of an application. So while the circumstances are horrific, and I am sorry that we are here today for more than just the legal aspects of this case, it's just a case where the law is very clear on what my limitations are and what the board's limitations are. And I hate to muddy this even further. This has nothing to do with the merits of this case. But I would be remiss if I did not say this case should not be before you today as a recommendation for reconsideration. And the reason it shouldn't is because it didn't meet any of the criteria that you require in order to be considered for a recommendation for reconsideration. You have very strict requirements on what is required. In this case, the petitioner simply wrote an email asking for you to reconsider her circumstances. And while I wish her circumstances were different, if you vote on this today, you are allowing someone to have a request for reconsideration that didn't meet any of your own requirements. So I am concerned about the precedent being set moving forward when you opine that someone didn't meet your legal requirements, yet this was simply, please reconsider my case.
So one thing to that, I will circle back to, as she spoke on the previous case before you all, it's impossible to meet the requirements that are set forth, so, for reconsideration. And that was said earlier by Ms. Blakely herself, it's pretty impossible to meet those requirements.
So do you understand that if we vote in favor of you, the property appraiser will be suing you?
I did not realize that until she said that on another.
That was my question was, so let me just, and I'm sorry to make you go through all this
No,
again.
it's okay.
So when you moved back in and sold your property and moved back in, what was that date again? You said 2024?
2023.
2023.
2023.
And then,
And my husband died in 2024.
and the sale and everything else and the transfer had gone through, and then you moved back in, that whole transition had happened.
Correct.
And there was a time period between when you entered that bill and then he passed, that you were together with him and taking care of him.
Correct.
Okay, I just wanted
Yes.
to, that was my whole.
Yes, and I provided proof that I had moved back, you know.
You did.
And I just, there's a lot of documentation. So let me ask you this, and that was what I was gonna get to, was if this moves forward and she's in a bad spot because she has to, as the property appraiser has to do that process, that would mean that you would then defend yourself against the property appraiser, which I know is a real bad situation. But we, in no way, are a part of that process. That goes before the secondary quasi-judicial link comes back to us, right?
If the board, well, if ultimately the property appraiser appealed the board's decision in the circuit court, it would not come back to the PAB. That would essentially be the end of that process. But it might be appealed further, but not back to the PAB.
Okay.
And the only other thing I'll mention too is as far as, the argument that there was no application for exemption, there was. I just filed it after my husband died and he was not there to unfortunately be able to sign for it to be adding, whatever that application type is called, to add me back to his exemption. So I did file an application, or and I would think that's what I was doing whenever I went in to remove his veteran status and claim the widow exemption, because that was granted. So if there was an application process needed, I would think the property appraiser's office would have presented that to me at that time to educate me on what to do. And whenever I got my bill, the exemption was there, so I'm assuming I filed that application at that time. Again, my husband just had already died and couldn't add me back as on his exemption, I guess.
I have a question.
Yes,
So the statute, if I understand what you just said, the statute does give instructions to notify the property appraiser, right? Does it give a time limit, like within 5 days, 10 days, 6 months?
I don't know off the top of my head. I'm trying to think that through.
And
I mean-
the question for you is,
Each year's.
my understanding is that her cap went up. Like the property was reappraised, reassessed, right answer, whatever the right term is. But normally, you don't reassess the property unless it changes hands. It's sold or bought. Which one you want to look at? Am I off base? Okay.
Yes, sir, but not intentionally. The property is reassessed every year based on Florida law. Every property is reassessed every single year. But what we're talking about here is the cap that caps the increases in the assessed value, not the appraised value, not the market value, and the assessed value based on an amendment to our Constitution. However,
It's you assessed it and said, well, the market went up X and her cap
Well,
goes up as well.
market became assessed because there was no, when Kelly moved back in with her spouse, when he was still alive, this is the most horrible case I've ever talked about. And if that happened in 2023, then that would have been the year that she would have had to file and let the property appraiser know, okay, I've sold this house, I'm moving back in here. So because she has to sever having benefits at one home to receive it at another. And that didn't happen. I can't take a homestead application in 2025 and activate the cap to apply for 2023, particularly when the person with the benefits is deceased. I just have no statutory authority to do that. The best I can do is let folks know and understand. And I, frankly, ladies and gentlemen, I do this all the time when people run for office and they live here and they tell everybody they live here. And I have to say, because you have now said you live here and you are married, you no longer have a cap. You no longer have homestead benefits. It's for your spouse only. And even though it's not going to change, the assessed value is not going to change, the exemption amount's going to change, you have to notify us when you move back. Because if you do not, and something happens to your spouse, you have no cap, you have no exemption. So, you know, in all of those cases, in the 40 years I've been either working in this office or been the property appraiser, the spouse hasn't passed away. So that wasn't an issue. You just move back in, refile like they have to do. Because you sever your rights to a cap once you establish a separate domicile for homestead purposes.
Question, is this,
Yes.
will this be full-time year, or will it be retroactive back, or is this moving forward, the established value is going to be that value?
Her assessed value is now capped based on the portability from the house that she sold in 2023. In 2025, we were at least able to bring her portability from the property that she sold to the property that she moved back into. That cap will stay in place now moving forward at the 3% or CPI, whichever is less, as in perpetuity until she sells or makes changes or adds new construction. That cap will be there. But that's not why she's here today. Why she's here today is the cap that her husband was receiving on his home ceased to exist once he passed.
I have a question on what you said prior to that about not being able to reestablish the domicile. But under the statute, she could have reestablished the domicile had she made an application or submitted the paperwork to you.
Yes, sir. I didn't say she didn't have the ability. What I said is you have to reestablish that is the domicile in which you are claiming as your permanent residency. Because remember, you file an application and you probably saw this information that says, I am not intact with this person. I'm still married. I'm not going to find a final judgment or in this case, prior to the person is still living. You're not going to find any of this, so I'm going to provide you all this evidence to support the fact that it is not, we are two separate people, we are only legally, but we separate income taxes, separate everything. So you sever your rights to that cap. The cap stays with the property. So there was no cap to move. She had to establish her own homestead with a new cap, which she did. She did that. We ported that to the home once she came in 2025 and refiled.
But she could have reestablished that.
She could have.
She could have restored it just as it, what happened was a simple piece of paper wasn't filed, or a request, or that was something that she just did not know that she had to do.
Yes, sir, but respectfully, the piece of paper you're talking about is the only thing that gives me the constitutional right and statutory right to give a homestead. She failed to file a new application once she was not living in property A and to move back into property B.
And I failed to do it before my husband died.
Pardon
Because I failed to do it before my husband died. Because again, if he was alive and I still had not notified them today, the taxes would be the same on a home. No change would have happened.
Can you speak specifically to the, oh, I'm sorry.
No, go
You
ahead.
speak specifically, you made a point that this is difficult because you who had worked there for as long as you have did not know that this was a requirement.
Right.
Even though it's statutory law, right?
Right.
Can you tell me that little process, like meaning when you were going back, you filed everything that you knew was available?
Right.
There are no notices that come to you, there's no nothing that says it unless you read the statutory law.
Right, unless I had gone back and read statutory law, there would be no way for me to know that. Whenever I sold the home, there's, and I understand, I guess, to that degree, but there's nothing to notify me, you've sold this homesteaded property of where are you now kind of thing. And I understand that that's, probably difficult, that that's not the property appraiser's responsibility. But again, I went back to the home that was in my name and had homestead on it. If I had moved back to a home that didn't have homestead, it would have triggered something like, I need to go and file to get homestead on this property again, but the home had homestead on it. And again, I sold the other property, and I just mentioned that because I work for the tax collector's office, and just meaning that somebody in kind of this world, I don't work in the property tax department, but I'm in more motor vehicle title and registration, but again, just somebody, I can't imagine somebody who's never worked in this type of industry would have any idea that if I, the experience that I have, did not know that. So.
Sir, can I respond to, your question hasn't been answered about the time limit.
Yes.
The statute clear, it says, anytime there's a change in homestead, a new application must be filed. That's 196.011.10. Also, in 196.011.1 says, failure to file by March 1 constitutes a waiver of that privilege for that year. So you got to read the statutes together. So if you change your homestead, you got to tell us, and if you don't tell us by March 1, you lost your privilege for that year. So when she moved back in 2023, according to section 10, she should have filed a new application, and if you didn't, you lost your privilege for that year. So you have to read those two statutes together. So there is a time limit on filing that.
If you're familiar with all the statutes, then you know that, because you can't just follow one.
Thank you.
Mr. Stowitz, I'd asked him a question, I wanted to make sure the board heard it. Could you explain that?
Sure. Yeah, so if the board were to grant this request and enter a final decision granting the petitioner's request, granting the homestead, presumably the property appraiser would appeal, and in my view, that appeal would be granted, that would have merit. In other words, the VAB's decision would then be reversed, and the petitioner would end up in the same place. There would be potentially an order or a final judgment out there saying that the VAB got it wrong, which would not be a good thing for a number of reasons. On top of that, I do want to mention, and the property appraiser did mention this request for reconsideration, it did not meet the requirements of the local procedure, but I don't mean on a technicality. It was one line without any substance whatsoever. Basically just saying that I want this reconsidered, more or less. It's my understanding that the clerk did respond to that and essentially say, we need something more than that, we need more substance than that, but none was received. So, on multiple levels, both in terms of the adequacy of the request and how clear the law is in this case, and it is a sympathetic case, I noted that in my opinion, but that can't impact the board's decision making. And ultimately, I don't think it would benefit the petitioner in any way, assuming that the property appraiser did go forward with the circuit court appeal. It would just be a lengthy, probably unpleasant process that ended in the same way.
I have a question.
Yes, sir.
What if the property appraiser didn't appeal their decision?
Then the board's decision would stand. Though, I would caution, it would still be, in my opinion, contrary to law, and there can be consequences to that with DOR.
Okay. But then that would be up to the DOR to determine whether they would review this, I assume, or would they? Or would they just simply?
Whether they would unilaterally, come to know of it, I'm not sure. But if it was brought to their attention, I think presumably the DOR would say this was a clear one, and the board.
Or maybe they would see that there's a spot in the law that needs to be addressed and corrected, because a situation like this really should be covered as an exemption to that there should be some kind of process, if there is a death, to be able to provide documented proof that I was residing back in a home. I mean, how many other things do we deal with on a day-to-day basis with government where there's an exemption to a process, and that all the situations sometimes aren't covered? And I do feel like this is one, I know they're covered by the law because of how it's written and applied, but I do think there's room for an exception to be written in this rule, that when a death occurs, I mean, they stated themselves in 40 years they haven't seen a situation where a death is also involved. I think it's just one of those situations that's not covered in the statute or the law to cover this as an exemption either. So maybe if it goes through that, they'll see that.
I would say that's doubtful. The Department of Revenue didn't write this law and can't change it. The DOR is created by law, follows the law, and they they apply it uniformly and consistently, and they want the VABs to do that as well. So again, this isn't for lack of sympathy. It's just that the law is quite clear.
I know the law can be gray, and I know in the world of criminal law we have prosecutors. They have 100%. They can determine whether the prosecutor can or not. They have complete discretion on that decision. And I just wonder if there's any room for discretion and compassion in this process. And if she's made every attempt to appeal and plead her case, it does seem to feel that she got caught in a rough situation. And so I would kind of take that, that approach. And, if the DOR has nothing more to do but to pursue cases like this, we probably are funding DOR way more than we should. There's a lot bigger fish to fry, and I just think I've read 196.00110. It's pretty complex, and I just wondering how much room we have for compassion.
I guess the analog in your example to the prosecutor, the closest there is, would be the property appraiser. So yes, I would say there's discretion conceptually. However, just like everyone else, the property appraiser has to follow the law.
Right.
Say that it's not quite an apples to apples analogy, but to the extent there's discretion, and again, that word's not quite. It's not with the board.
I use another analogy. Law enforcement exercises their discretion all the time. In their laws, they just choose not to enforce. And they have that discretion. And And I just was curious how that would play out if we were to leave here.
The other portion of it is that unless there is something like this that becomes such an issue that rises to the level that it needs to be fixed legislatively, normally it never gets fixed. Meaning that in the event that there's an event that happens that draws enough attention to the subject that we're dealing with, it will never get fixed. Even if we petition the state legislature to say, hey, we ran across this problem, can you guys help fix it? It won't really rise to the level of a DOR, property appraiser and everybody else in this action that we're trying to.
No, because I'm one person, so, yeah, it'll fall through the cracks and it'll continue to fall through the cracks and other people be affected by it, sprinkling here and there. But there won't be enough of an impact for anything to be done.
I have a question for you on the case, and I'm sure it's spelled out here, but you got a second homestead exemption, separate from your husband. And your husband died. When was that homestead exemption done away with?
In 2023, whenever I sold that home.
And you sold the home, so there was no homestead exemption. Okay, and then your husband died, and you moved back into his home.
I moved in before he died.
You moved in
back in.
before he died.
Correct.
So you assume because you moved in before he died that you were wed and you were protected.
Correct.
Was your name on the deed during this time?
Never changed.
Never changed. So you had common property and your name was on the deed.
Correct.
So you assumed, under Florida common law, you were on the deed. You had legal rights to the home.
Correct.
Do you still live there?
Yes.
You still live there. And you had to take no legal action to change the deed whatsoever. It remained in your,
Correct.
and you were living in the home when you died. Okay, that's interesting to me.
And had sold the other
Yeah.
property again. It's not like I was benefiting, back in the home and benefiting from a homestead. It's obviously that would not.
That's why I asked that question, basically to remind everyone that it wasn't that he passed and then she moved in. She moved
Right.
back in to establish that residency.
Right.
Yes, and I've provided documentation to prove that.
And when you moved in, you were his legal wife.
Yes. Correct.
So y'all never got divorced.
No. No, I didn't.
Okay.
And again, I pointed that out earlier too, because had we had gotten divorced and remarried, I would have been eligible for his cap and his exemption on the previous value as his new spouse. If he had married someone else and they had moved into the house after he died, they would have also been able to assume that exemption and his cap. But because it's still me and that I had established that other homestead, that's the part that's catching, where they're saying I can't. Yeah, and I understand it's the law that's stating that, but again, it's a very small percentage of people that are going to fall into this situation, and I do feel that statute is, like you said, it's very cumbersome. It's quite involved. I knew my situation and had trouble reading it to find where they were coming to this conclusion. So, again, an average person is not going to be able to read that and understand that. But it also seems like there's room in that where something does need to be added as a catch-all for a situation where there's a death. But to your point, I'm one person, and that's probably not going to be enough to get a rule change.
So the home that you sold, you did
But I'm going to
establish.
keep trying.
Okay. You did establish a second homestead exemption in the home that you sold. It's interesting. It's interesting to me, there almost seems to be a conflict of law here in the fact that
Yes.
under Florida law, common law, husband and wife are deemed as one individual. They share property together, but yet the process by which a property appraiser can sever that homestead seems to even preempt that common law or the common property law of husband and wife. It just, you could see how a reasonable person would assume that.
I agree with you that there are some other angles to this that I think may not be seen.
Right.
If I can ask a procedural question, if we accepted the petition to deny the agricultural exemption, that would go back, this is
Going back to the
process.
first one?
Yeah, just following the process.
Yeah.
That would go back to the special magistrate, and then we would have to have another meeting prior to, right? So if we decided we would already have another meeting, would it be proper to postpone making a decision on this one until we can kind of think about those other angles to formulate an argument, and then come back if that was the case? If we have a second meeting, or do we have to make that
The
decision?
board could do that, assuming we can get another meeting scheduled in time. I mean,
When is the in time need to be?
May 1st, ideally.
I'm just trying to figure out. So we would have to have another, it would have to go back to the special magistrate for the agricultural exemption. And then we would have to schedule another meeting prior to May 1st in order to successfully be inside of that. Okay. I just wanted to try to figure out that whole process, because there's a lot of areas that I think you're speaking to that I think I'd like to take a look at, but that's a little.
May I ask Aaron a question?
Absolutely.
So Aaron, I have a question. So if we today decided in favor of the petition, my understanding is that it makes us look bad.
Yes, I would agree.
What else does it do?
There's an immediate problem, which is how do we write that decision?
Okay.
I don't know how to write a decision that clearly doesn't comply with the law. So the board can direct me to direct the magistrate to do that, and I can help the magistrate. That's the normal process. That's the correct process. But the only thing I can say that could be done is essentially saying that the board, notwithstanding the law, has directed this. And that's not good. That's a terrible way to write a decision. But I can guarantee the magistrate's not going to sign something that says, something contrary to the law. And I'll be candid, neither can I. I would have to have that proviso essentially in the decision.
So then people who are coming before us that have cases that are unusual, it almost feels like we can't help them at all. So why are they here?
Well, I would say some requests for reconsideration lack merit legally. I'm not going to say that they shouldn't be here, but some requests lack merit and should be denied on the law. Unusual, sympathetic, yes, but the law doesn't look at that. The law does not look at hardship at all with respect to anything that comes before this board. And I don't mean that in a harsh way, but it is crystal clear. Those terms are in the law. Hardship is not relevant to any of the substantive considerations.
I don't see anything in the law that addresses her situation. I'd like to see in statute what she violated. There's an effort to link other statutes and other situations, but in her specific situation, where she moved back in, she did away with the homestead, she sold the house, that went away, she moved back in with her husband, lived in the home. They were a couple. I'd like to see, and I can't find it, maybe you can, I'd like to see a specific citing in statute that shows that she violated something and didn't do something proper.
I can prepare a more thorough opinion, but it's not going to be substantively different, I don't expect.
But I mean, I'd like to see in statute, basically, what it is that she violated, and does the statute even address this horrible situation? And secondly, is there case law? Has this been litigated? That'd be interesting to see as well.
Really, the issue is not complex at its legal core. It's that the property appraiser cannot grant an exemption without an application. That is really what this comes down to.
An exemption to what?
Without an application for that exemption. It's not
Exemption
automatic.
for what?
For homestead.
But what do you mean exemption? She had homestead. She was living with her husband. The property was homesteaded.
And he had the exemption, and I should be able to get it as his.
Previously had.
Yeah, it's your spouse, though. If your spouse has an exemption, you're living there, that's your homestead too.
Well, there may be confusion because there's two different homestead. There's a homestead exemption and a homestead protection under the Constitution. They're two separate things. The protection's automatic. You don't apply for it. It gives you certain asset protection benefits. we're talking about an exemption it appears to me that she qualified for the exemption. But that's not enough, you have to apply. If you don't apply, you can't have it.
So can I bring up one more thing, and I don't have it in front of me, but whenever I first submitted my petition, I had tried to find case law as well to see if I could find where this has ever happened before. I could not find any, but I did find case law where there was a different situation, but the application for homestead had not been filed. And in that case law, they did go back and give the exemption to prior years based on the fact that they were able to establish that the exemption applied, they just had not filed for the exemption. There is case law documented in there to that, where that has been overturned in a situation and an exemption applied later. Again, I know it's not my exact situation because you're not probably going to find that exact situation because it's so rare, but there is case law in there cited where an exemption was applied for prior years.
That case was a Spain case, and what happened was, gentleman had homestead, and he married a woman, and then she got his homestead. The difference between that case and her case is that woman never had homestead anywhere else. Mrs. Grantland has homestead somewhere else.
Did have, but I had sold the property.
But she did have
I had sold
homestead,
the property.
she had no homestead at the time.
Not at the time, I did.
Her husband died.
She had the benefit of the homestead from her previous one. So that's the difference. That what distinguishes the Spain case from this Grantland case.
And my argument inside what I'm thinking is that we have under what's brought before us, no way box to get out of, right? Like this is, our attorney is saying we have to do this, and this. Where I agree with you, Mr. Altman, is that there may be something else out there that we're missing that kind of gets before this process and before all of what we're doing right now to re-establish her in that role, whether that's prior case law, whether that's something out there. And I think for me to flush that out would be worth it. The only problem I have is I would meet tomorrow if you guys ask me to. I don't know what your schedules are to have another meeting. I don't know if we have enough time to go down that road prior to the May 1st. That's all.
Well, there's no limitation on my schedule, so it's up to the board.
Just in general, you guys, whether it's this, whether it's the other ag piece, we would have to have another meeting coming back.
Sure.
Are you guys open to trying, I'm not saying we vote one way or the other on any of these, but it would make my decisions a lot easier if I knew you guys would not be willing to come back before May 1st, that's all.
I would be.
I would be before the 25th. I'm out of country after the 25th, but.
Are you good?
I'm good, I'll support you.
Okay. Yeah, just from a schedules perspective.
Yeah, tell us when.
Can we get the special magistrate, the agricultural one, I'm sorry, this is a kind of a procedural one. If we agree with the property appraiser to reverse that, it has to go back to the special magistrate and then it has to come back to us, right?
Yes.
Is there time to do that between now and the 24th?
That part of it probably doesn't take too long. You know,
Okay.
me and the magistrate could probably revise a decision in a matter of days or less. That usually, assuming they're available.
Okay. From a procedural piece, I just wanted to, that's all. Okay, thank you. What do you want to do?
Do we need a
Okay.
motion to suspend it?
Yeah, I would say that. Do you want to do it? You want me to do it?
Sure, yeah.
I'll motion to postpone this until a date that we can rectify it prior to May 1st, if that's okay with you guys.
I'll second that.
Can I ask you maybe to include something in the motion to ask that we get more information, copy of pertinent case law, specific statutory violations?
See if there's something ahead of it.
Right.
Right, counsel.
I'm happy to prepare that.
Okay.
I would suggest that if, you know, maybe ask the parties to do likewise.
Yeah,
Yeah,
It's up to the board, of course.
Okay, right.
appreciate that.
include all of that in the motion.
All the affected parties.
Yes.
Yes.
Do you want to restate
Can I just
that?
ask a question before you vote on the motion?
We have a motion already, I think we got a second, don't we?
Yes.
But we can still discuss it.
Yeah,
I just want to make sure I'm understanding that what you're voting on today is that you are accepting that this petition met the requirements to be considered for a reconsideration, and you are taking a vote based on that.
can I speak to that?
Yes.
My motion? No. What we're doing is postponing it to a later date so that we can gather more information to see if there is something else that we may have missed as a board. That's it. So that motion would come at the next meeting where we would have that conversation and that decision.
Right, but the procedure available to you now
Is
is,
the same procedure we would have in a couple of weeks when we have another meeting.
yes, sir, if I may finish. The procedure that you have now is a request for reconsideration. So even if you table it, it's still a request for reconsideration.
At the time when we bring it back, yes, ma'am.
Correct, whether it's now, whether it's 2 weeks from now, whenever you
Yep.
bring it back.
Yeah.
So what I'm asking,
Or whether it's 5 minutes from now, if we deliberated 10 more minutes. Or we
Right.
took a recess and we asked the council to do some quick research.
Yes, ma'am.
I
Absolutely.
am concerned about the precedent that you are setting. If you have a request for reconsideration where none of your criteria to meet the standards of a request for reconsideration were met because you denied others that did not meet the requirements of your request for reconsideration.
And what I would say to that is that due to the usual circumstances and some of the facts behind it, we may not have seen some of the things that we would be able to uncover, whether that's case law or something else. So we're not making a decision formally on this right now, and we can postpone it. Not postponing other ones and making a decision later is not any different than actually voting on it now. So there's no, we are postponing it and tabling it, so I would disagree with that statement.
So you're postponing whether or not you're going to consider reviewing this case. Do I understand that to be what you're doing?
We're postponing the judgment.
We're just extending
Yeah.
and getting more information.
We're taking more time.
Taking more time. Okay, is there any debate, discussion? All in favor of the motion signify by saying yea.
Yea.
Yea. Opposed? Carries unanimous. Okay, we will move to the next item, which is 2025-01334, which is Kalinia.
That's the one that was before.
Oh, is that?
Doing the first one.
Come back to 95.
Oh, we go back to 95, okay. Scrolling through the agenda, so that would be at the beginning, okay.
Watermill Holdings? Yeah.
By Watermill Holdings, back to
Back to the first one.
0095. That's right, because we didn't have a, is this the one you're here for? Did we cover?
I don't know
No.
which one I'm here for.
No, she's not.
I don't know if we had your item.
Malabar Hallway, I don't see it on
Yeah,
here.
okay,
so
that's
I-
what threw me.
Yeah. There's a, so when I told Nicole, she is not present to send this, but she told me that the meeting is here.
I've seen
It's
it.
not
I
a
did-
VAV
It's not. I didn't send the letter. I don't know who did. Somebody from the city of Palm Bay used my name and the VAV's phone number because there was a meeting here today. And something about land clearing and a burn ban, but it was not authorized or sent by Nicole Summers.
Yeah, because it says Titusville, the Atlantic Room in Titusville, so I don't know what.
And that's because the VAV meeting was actually here, but there is the tax account number that is in question that will come before the board if they adopt the recommended decision today.
Okay.
I forgot what the tax account number was, 303
It's here.
2508.
302-5028.
Close.
Like, which one of these?
It is not on there because it's not for this, no ma'am. I don't know who sent the letter out, but we did receive at least 10 phone calls about it.
Yeah.
Yeah.
Is there a way
Not
for you
me.
to track down who did that? That's.
No, I have a copy of the letter in my email, but I don't have a way of tracking down because it's not on letterhead. They didn't use my last name, but they did use the VAV's phone number.
And the envelope that they sent it from, it was from Orlando, and when I looked up the address, it was the UPS store. So, I mean, I don't know who sent it, but I do know that,
When was it
There's a
sent? When
problem.
was it sent?
I received it on Saturday.
And so, do you know what the name of the UPS store was that it was attached to? 'Cause I'm gonna
On
get more security.
Chickasaw,
Does the
I
board
might have
want to
brought
find
it
the
up.
letter?
I would like you to.
Yeah,
Madam, would you mind showing me the letter?
because that pisses me off that somebody would use our name, send people to a discredit that.
Yeah, because sorry. So that's where it came from.
Handwritten.
Yeah, when I looked up this, yes.
So what happens is, and I deal with this in insurance,
Yeah,
these people are used car salesmen.
yeah,
And so what it is that each UPS has PO boxes now.
right.
So they have companies that will establish their residence at there. So this company, CRC Realty, is probably who did that.
Probably,
And if they illegally doxed them out,
And they CC, Commissioner Atkinson, I believe, I think they CC.
yeah, because J&L was talking about that last night.
Yeah.
I didn't see it.
well, I'd say we need to
Well,
sort of
it's
send.
definitely an issue I'd like to speak to, whatever.
I
If it's
We
not
deal-
today, I'd like to go on
So-
the list to win.
I don't even
about
know
all
where to
that.
begin with.
So I don't, so you are not, I don't know
I guess
your
I'm not even
specific.
supposed to be here.
No, it's okay, your specific case, but what we're dealing with is, and we deal with this on school board, we have people out there that put our name and our logo on stuff and then send it out. And that's illegal. We've established that, that needs to be addressed, because if you allow somebody to do that, then they will. So I'd like to have a discussion about it at the end. I'm sorry, ma'am, I don't know.
Yeah.
Maybe he can help you, he's our attorney's much smarter than me.
What I see here, if I had to make a guess, it looks like something AI created.
Yeah.
It does have a section that says Value Adjustment Board Meeting, April 8th. It refers to 400 South Street, Titusville, Atlantic Room. But nothing else here seems to relate to the VAB, at least as far as I can tell.
Talking about reinstating their agriculture.
Yeah,
Basically, the activities that are going on there, I would like to see stopped or curtailed or managed
I
or
don't
something.
feel like
this is nothing but
We're gonna
VAB.
take a 2-minute
Okay, I'm sorry.
recess.
Yeah.
Yes, Commissioner Atkins, let's take a recess.
If
We'll be
you, I
back
mean,
at-
I'd like to keep the
Yeah,
a copy of the letter, but
No,
you're
this is-
welcome to have
I took a
one.
digital copy.
Okay.
What's the background? I just want to try to see one in the right direction.
Just so you
Okay.
know.
But can I grab myself and we'll talk outside?
And it becomes a bigger issue, because we established the fact that we could move on and stuff like that. So we've taken a strong stance to trademark all of our logos recently. We did. Okay. I mean,
And what's your name? Lisa Brown? Are you the one, okay, thank you, you're the one who sent me a copy of it, okay, thank you. No, I was like, no, I was like, no.
Charlie's.
Yes, okay.
Charlie's the one who you okay.
Yes.
Don't have any bad
That's okay, that is okay, that's okay, I see that. I'm not gonna say much.
so you tracked it down, you actually found the person that did it.
I honestly,
Maybe should I wait?
I can't even tell you, I don't even know. I'm not sure, okay?
I'll just say.
Okay.
Holy shit.
And I'm the landlord there too.
Okay. So, all right. I like-
Multiple, yeah, a lot of people
That's
received that letter.
So,
And all of our
may I take
stuff
pictures
is-
of this document that you just showed me?
If not, I can email it to you, Susan, as well.
You sent everything,
I know I have.
to her?
I can see it.
Okay, if we can do that, that would be great, but if I could move on a little bit.
I don't need,
Yeah, I wondered if there was.
No, I just need digital copy, I can take pictures of that, that's all I need to do, if I could just take a second to do this.
this is who he is. He sits on the board. He sits on the
Let's go
system.
visit him. I can visit him.
my name on it.
Yeah, wait, that's basically, okay, let me get off the top.
I was hoping that I could get out
Take pictures of it.
for you.
I'll delete that.
It's a big question. I saw it this morning.
You
So why
guys, you
did
can
it,
have your
what was the
attorney validate.
purpose, what was the purpose behind this?
Is it
He
possible to
told,
schedule?
I had my office girl call him and
Okay.
say, "No, I understand your child's letter." He admitted everything that way. He said it's because development project that he wants to do.
Holy shit. So he causing chaos.
Yeah, I think he's trying to push us into selling our property, which we've been a farm for, I've owned it for 26 years, our family. But it's been a farm for over 100 years. It's actually the original Pat's farm that founded
How long
now.
have they been to go through all this?
Yeah,
Figure out what this, because this, did you hear what's going on?
No, and I wanted to ask, I just copied on it?
Well, Rachel, Raquel, she was a neighbor, and I brought a letter from
Well, I
her.
didn't.
I was so organized.
She's already been through this.
Where is this
The
at?
magistrate, and she's already, we have an ag exemption, and we've already been through everything.
So he's-
Today, we're on the docket to have it,
He falsified documents to
And
tell everybody to
and a
come
lot of
back.
lies and shit.
I was our neighbor, and she said that, like, this house is amazing and all that stuff.
So,
Is this a single letter to the other one?
This is a good letter.
He said we weren't in compliance, but we
You have this
are.
guy's phone number anywhere?
He said we were being sued by you guys,
This
and
is
we're
another
not.
letter from the local environmental
Who is this guy? What's his name? What's his name?
Brent Howells.
It's right here. It's got all his name. You want it?
That's a lot of defamation.
I'll make sure none of your stuff's on here. Is it okay if I take this back?
I think it's on there.
That was another.
Yeah, just like that.
So where is this at?
And we got,
You're gonna-
it's coming, we've been in Antarctica for 6 years. But I think
Is
it's
it on for today?
Magistrate.
It's on the blanket, when you guys make the blanket, adopt and finalize with all the other recommendations. That's gonna be open.
Looks like,
No,
there's something close to this.
it's just gonna be a blanket, approve all of them, and that's it.
385.
Then they have to have a.
Yeah, so if it becomes, that's gonna find it.
Okay, so you got all portions of this.
She owns all, over 100.
My family owns the whole thing.
So, so where is your property on here?
We actually are partners with them.
Okay, all right, so
I own it.
he tried to send you guys down here to say, cause chaos. That's what he did.
He said no, that letter to
It's owners of.
No, we are there.
No, but I mean, like, who do you send letters to?
All the people around here.
So he has a development property, does he own something in here?
Figured that out. I looked at everything. He owns property in Palm Bay, but he had a, I'm not a first deal, I don't know. Entity set up his house, Palm Bay, but it's inactive, so I think he wanted to move the project. Maybe I found that. This was in.
What is his, do you have a phone number somewhere? Can you get contact, somebody call?
Yes, I remember that. I remember that one.
I just received, I got a forward, we did 2 crockpots, leftover ham from Easter, but got in the crockpot.
Where's this at? What's in
All the like, take one out, daughter is doing things together, and with corn for them, and
I
we
just
ate,
want to let
and all
everyone
done.
see these guys not to be.
Sorry.
Trying to keep you out of it.
Oh, yeah, they didn't.
I'm over the top.
I do too, I love with good corn, like I eat, oh my gosh, yes.
Yeah, we
That's okay.
So you,
I mean, one of the members
so, but I mean, like,
we work together.
so here's what I did, I'm sorry.
It was perfect, it was rainy night, so
They took your name.
it was perfect, that I
Brought us.
actually got out of it for that.
What I would like to do is Sue,
Yeah.
bring it forward.
Put that in the black box.
What we can do next. We're dealing with this.
Property, vacant land, or something.
You can see all this stuff. So let's stop.
Somebody owns the property.
Right, let's stop. Let's, yeah, well, the
Burning,
network.
clearing, bad. Somebody who cares.
We have a valid back, I'm pretty sure.
No, it's a CDD, so it's like one of the golf courses out there, sitting on it. You can't sit on CDD.
And this deal is full of missing. Yeah, that's basically.
I just was like, he's constantly asking questions to someone probably.
Right, Howells, Sunrise Community Development District, 4 years.
It is one of them.
Maybe that's the connection.
And I think that is the town, the town manager,
Here's where the matter came
when
from.
that's when the county funding.
Right here, CNC Real.
So the part on the, on this, I told him that.
Registered over there, see that address.
I don't think this is him, right?
You know, they, the board of everything that.
He also had a,
So right now with that, I got the next phone call.
Yeah, so what this is
Say about supposed letter.
they print out
But he owns this company, and it has that address.
right, so what I ran into, so I did, so I did really my real life, not my massive large house.
But other than that, we're gonna approve it because it's one of the.
That's just one of the regular stuff.
Yeah.
Get a hold of my elected officials and
Well, that company.
exactly what he
that's what she said.
Clearing the amended use that.
What happened? Now, this thing, she was.
I said, my best guess is just like, you know, or maybe.
We have to fill in what's happening. This has nothing.
And you got the experience to say that, don't you?
Once again, it's one
Right, so he's also a developer. I'm showing it was the and what he does, sends out falsified information to the DEP. All these people are trying to create districts and purchase and develop.
Instead of going down.
No, we can.
I mean, there's no comparison. Once they go, it is, you almost want to pull out a barrel for it.
All kinds of stuff.
That's what today is.
They got the same letter.
That's really.
Yeah, I got read for it.
So
I can't figure that everyone's like,
I was
constant. I
yeah.
said, back up. Wait till I tell you. Like, Chicago, that's dangerous, field, you know, like, it's gonna be cool, you know.
State Center.
And in Ohio, that's like, and they
What I'd like to do is let our attorneys go out and making time for us. We have to stop the meeting to figure out what the hell's going on.
And wait for the ladies. Whoever else might be here for this.
That's it. Every time everybody's time. Now, if I know this guy, he's a very strong developer and a private attorney, like, he'll be never going to get us. So that's what we need. So you guys gonna hang out for a little bit, you guys actually can find out. All right. Sorry, you guys gotta go.
Sorry. That's all right.
Thank you.
I'm just sharing everything. Toledo, clerkship's on.
Right.
Received some mails.
We'll go back, we'll convene. We'll go back to the first item, 2025-00095.
This is the agriculture.
Yes.
Okay. Sorry, I was trying to charge my documents. So thank you so much for bringing this forward. Can you explain to me some of you came to an assumption that this is no longer an agricultural property based on those assumptions, and I read through them. You had said that they had applied for tilapia, they had applied for these things, but then there was never any proof of them. Can you walk through that a little bit more?
I'm gonna let George handle that because it's a bit more nuanced than that.
Yes.
What the agricultural operations that you are describing were the agricultural operations that were applied for and granted by the previous value adjustment.
Romalia Farms.
So I'm gonna let George give you an overview of this case.
Thank you, George.
The 2024 VAB granted the agricultural on this property for cattle grazing because they had cows. And there's a large pond on the property. The owner said they were growing tilapia to sell to local restaurants. The tilapia had not reached the right size yet, and they were working on getting contracts for local restaurants. In the meantime, they were doing fee fishing, which, like strawberry picking and blueberry picking, you can go to their property, catch a fish, they weigh it somehow, and then
Do that in the mountains with Santa.
so, in November of '24, Romelia Farms closed. It was well known, it was in the newspaper.
Yep.
We had notice from the gentleman who supplied the cattle to the property that he removed the last of the cows in December of '24. The tilapia operation never happened. They never started selling to restaurants, but the fee fishing happened. Fee fishing, if you look under, I can't remember, I think it's chapter 570 of the Florida statutes, fee fishing is an agritourism activity, not an agricultural activity. So if you do fee fishing, that doesn't qualify you for the agricultural classification.
Right.
So as of January 1, 2025, the cows were gone because they were removed in December of '24, and we believe the fee fishing did not constitute an agricultural activity. That's why we denied the exemption for the classification as of January 1, 2025, because those activities did not exist.
Now, we did have an appointment to meet the new owners to physically inspect the property because the gates were locked as we're going through and doing our inspections toward the end of the year. Because whether or not there's an ownership change, and that's part of this as well, change in the managing partners of the corporation, whether or not that exists or it doesn't, that doesn't avail us from having to prove each January 1 use, ownership and use. Yes, you've had ag before. Yes, you should continue to receive that agriculture exemption for the current year because that operation has continued. So when you go by the property and the gates are locked and there's nobody there and the articles in the paper say, the farm's closed, and we were all sad. It was a great petting zoo, and they were doing wonderful things out there that didn't qualify them for ag per se, but the petting zoo part was great. They were saving animals and things like that. But it was closed. So when we finally said, hey, we're going to deny this, if there's doesn't seem to be a use there, we made an appointment with them to inspect the property so they could show us their cows and their tilapia. And we made the appointment with the new owner, and then she contacted us back and said that under the advice of her attorney that we were not going to inspect the property. So hence the case went to the Value Adjustment Board.
And then they didn't bring forward any receipts, I think I saw inside there, that showed that they had been selling anything from the actual property.
In the VAB case this year, they provided a bunch of evidence that they're converting the property to a nursery, but they did not provide any evidence for the previous use of cows and tilapia. Correct.
Right.
So had the new owners, whenever, current owners, whenever, applied for, said, yep, you're right, we're closed, we don't have any cows, obviously there's none here. Obviously we're not even letting people come in and fish because the gates are locked. Had they at that time said that we are making affirmative steps, this property's in transition, and as of January 1, we're going to qualify for nurseries, that's something this office can consider. But we can't guess if you're open or not. We can't guess when we don't find cows that has continued. We can't guess that somebody's jumping over the fence and fee fishing. Can't do any of that. So, this is.
Did I miss the nursery application? Because in order to get to a nursery, you have to apply to the state to get a nursery application.
They are preparing the property in '25 for a nursery. So there was not a nursery, an active nursery as of January 1, 2025.
So there's no application for a nursery. There's no proof that there's anything on there. They're not
We
letting
sit
you
here
on
today, even in 2026, there's no application for ag for a nursery.
Yeah,
Okay.
Can I ask?
It was the same one.
That was the same owner.
That was the client, yeah. More or less.
So I don't know if you guys heard that. Can you say?
No, I didn't.
I asked him, what was the justification behind allowing them to continue to have an agricultural exemption?
Yeah, the recommendation was primarily about the continuation of ownership.
Right.
And the finding was that it was the same ownership.
Not based upon the justification of locking gates, not on actually sitting there and not letting people on, not any of that stuff, but no, with no nursery application, none of that. And they're not even here to defend themselves.
Yeah, I read that they allege that the property appraiser only emphasized ownership, and they were able to dispel the ownership, but we've heard testimony that they were looking at a lot more than just the ownership. It was the actual land use, and had some pretty strong evidence that had ceased prior to. So
If we did not.
I'm inclined to agree with property appraiser on this one.
As am I.
And it happened
Yeah.
based on those standards.
If the board wants to grant the request, thereby denying the agricultural classification, excuse me, then really what I would need is some findings and some really holdings, more like, to tell the special magistrate how to change the recommendation. And I can flesh that out. I don't need word for word, but some direction from the board would be needed.
Can I ask you, you're making the argument that he never brought forward any proof to actually have that agricultural exemption, right? So,
He never offered any proof. The proof we had was just the opposite. We had the cattle provider say, I took the cows away before
Yeah.
January 1.
so that is the argument that we want our special magistrate to re-review, which he did not review in the previous one, because all they did was say that this is the previous owner is what I'm hearing. Does that make sense to you?
I think that would be your decision, but yeah, that's our contention. That and the fee fishing is not an agricultural activity, it's an agritourism activity.
And that there's no application for a nursery, they've not been allowed to be on the Kansas site, everything else.
To be honest with you, nursery is a next year issue. Nursery was never part of our denial for 25.
And they're trying to put up as many things as they can in order to try to say, oh, well, and I just get a little upset that they would try to take what Romalia Farms built there and try to tail end on it to try to save some money. That's not fair.
I understand.
That's where I'm upset about. All right.
One perhaps simpler way to handle it, if the board wanted to grant the request, the board could adopt the findings put forward by the property appraiser and property appraiser's request. So you don't have to list them out for me on the record. You can essentially adopt their position. That would be an easier way to do
identify
it.
them kind of in that format, our, in our objection and our request for reconsideration, which outlines each findings of facts, conclusions of law that we disagree with citations and references to the evidence that supported otherwise. I'm paraphrasing here, but this whole case seemed to be with the magistrate based on the ownership. The ownership did change or didn't change. The first thing is if you change managing partners more than 50%, you're supposed to notice with APR
435 or something.
435, it says, hey, while the entity is still the same managing partners, more than 50% has changed. And that lets us know, that's what you file with us. They didn't do that. But when we met with their attorney that represented them, an officer of the court, and he says, yes, the ownership changed. That meant to us, we have to hone in on, the ownership is, change in ownership requires a new application, period, right? But that didn't exist. That was just the officer of the court's records. Now, we have no reason to think that the attorney is not being truthful with us. I think the bar would say you need to do that as well. But we didn't just rely on that. Again, even if the ownership doesn't change, which appears that they made some changes in Sunbiz, after January 1, you still have to use the property for agricultural purposes for, those agricultural operations for which we have an application and you've said are going on the property. So it seemed as though, which is why we filed, that the magistrate stopped with, nope, there wasn't a new owner. Whether there is or there isn't, you still have to continue to have that classification. So that's, I think, and I'm paraphrasing in a nutshell, why we said, hey, you can't just stop at ownership. We can't stop at ownership.
I'm just getting angry at somebody trying to lie about what they're doing. And that's what I feel is happening here. Okay. Or you guys have anything to say?
I just had some questions. I know in the document by the attorney for the landowner, stated that they submitted evidence, photographic evidence showing animals present on the property in January 2025, materials related to apiary use of the property and documentation describing agricultural, livestock, and nursery activities, as well as introduced invoices and other materials reflecting substantial agricultural investment and development activities during 2025. Did y'all see those?
Yes, sir, if you look at the evidence, the pictures were of goats and pigs.
Donkeys?
I don't-
Two camels.
I think there was with, the new pictures in the evidence. The pigs and the goats were used for keeping, instead of mowing, they were using them for, ground cover maintenance,
Interesting.
which was not what was granted by the VAB. The VAB granted cattle grazing with cows,
Okay.
not raising, pigs or goats, which would require a different application.
How about the invoices they claimed that they submitted? Did you see any invoices?
They submitted invoices for feeding the animals that they had.
Okay.
Yeah, but it wasn't, it wasn't cow supplement.
Bona fide agriculture. Okay. Thank you. All right. What is the desire of the board?
I'll make a motion to approve the petition to go back to the VEB, and then or the special magistrate, and have them reassess and come back based upon what we've found as far as not being the owners, but actually the merits of agricultural operation. Does that make sense to you guys?
I'll second that.
Second that, do we need to add anything to the motion?
I would say if it's the board's desire to adopt the findings and conclusions of the property appraiser's request, then I would just add that, if that's what the board wants.
Okay.
Yes.
So we'd include
Is that
that
okay
in
with
the
you?
motion.
Yes.
Okay, great. There's a motion,
I
second.
want to make sure that
Yep. Any discussion? All those in favor signify by saying yay.
Yay.
Opposed, nay. Carries unanimously. Thank you. All right. Okay, now let's move on down the agenda to item 2, new business. Other requests for reconsideration.
That's really a catch-all, but I don't think there's
Yeah.
anyone else here
Okay,
today.
all right. Approve denials of petition number 2025-00834 and 2025-00296 for non-payment.
And that's mandated by statute if they don't
Okay.
pay reasonable taxes. Timely.
official vote on that.
Do we
Just need
need
a motion here.
Do we need to vote on that?
I make a motion to approve the denials.
Second.
All those in favor say yea.
Yea.
Opposed, nay. Carries unanimously. Okay, number 4, adopt and finalize recommendations of special magistrates for petitions to the Value Adjustment Board for 2025 tax year. Approve the 2025 notice of tax impact and authorize the VAB clerk to publish the tax impact notice.
I
Because
believe this is where I have to recuse myself, isn't it? Yeah.
it is,
Because we're looping them.
and the only, really what the board can do is adopt all of the recommendations except for the 2 that the board is not, has not finalized yet. I think, is that 95 and 1334? And then, if you want to put on the record your recusal, and we also, because we're not going to finish the final decisions, that's as far as we can go on number 14. So only to adopt the recommendations other than those 2.
Is that what you'd like to do, or do we bring it all back at the same time as the difference?
I would say finalize them today, better to have them done.
Start moving. Okay. Is okay with that?
Okay, we got that in the record for the motion?
Is there approval on the record? You have this? What was the, do you have the name of the petition that you needed to recuse yourself on?
The number of it, I don't.
The number or the name of the owner, just so we can put that in.
It's me.
Oh, your petition?
Mine,
Okay,
yeah.
then that's enough.
Okay.
Just note that she's recused from her own position, of course. So if the board wants me, the motion would be to adopt all recommendations except for 95 and 1334, and adopt them, to make them final decisions.
Okay,
So I'll motion that. And we need a second.
is there a second to the motion? A second to the motion, any discussion? None, all in favor say yea. Yea. Opposed, nay. Motion carries unanimously, with one abstention. Right?
Yes, sir.
Yes.
Abstain, and that's Commissioner Atkinson. Okay,
For 5, the board can authorize the certificate for the tangible personal property, but not the real property. So that would be my recommendation, is to do so.
okay, is there a motion on the tangible personal property?
Move to approve.
The motion to approve the tangible personal property, is there a second?
Second.
Second by Commissioner Atkinson, all in favor say yea. Yea. Opposed, nay. Motion carries unanimously. 6, grant permission to advertise and set compensation rate for special magistrates. Okay. Any motion, discussion, questions?
I'll make a motion to grant permission to advertise and set compensation rates for special magistrates for 2026.
Second.
Motion and second. All in favor say yea.
Yea.
Opposed, nay. Passes unanimously. Okay. Item 7, authorization of ministerial adjustments. Authorize VAB Council to implement ministerial, clerical, or computational adjustments necessary to carry out the board's rulings, including any resulting changes in the notice of tax impact without further board action.
This isn't really needed today.
Not needed today. Okay. Item 8, discuss an extended VAB private counsel agreement with Aaron Fallwitzer.
Yes, so we're really at the organizational meeting, which will be coming up it'll be the first meeting for the 2026 tax cycle. The board's required to hire private counsel. It does not have to be myself, but my contract does expire before the organizational meeting. I suppose the board has a few options. The board could allow that to happen, but you'd need to have a new counsel before the organizational meeting, and likely, through the summer, because there are things that come up. The board has, I think once in the past, extended me up to the organizational meeting and then considered a further extension at that point, or the board could extend me for another year or more. It's really in the board's pleasure. I'm grateful for any extension. I love serving the board.
Last contact, Mayor.
Yes.
Last contract we did, is that a 3-year contract?
I believe it was a 1-and-1, so 1 with a 1-year extension, if I remember correctly.
And that was on the tail end of a 3. And then
I think
that's usually what we do. So the discussion before the board is do we want to extend another year, or do we want to grant them another 3 years or 1 extension?
Those are 2 options.
Yep. I mean, we can pretty much do whatever we want.
Yeah, I would extend, and it's up to us what,
Length.
yeah. Is it the same rate?
same rate, yes, sir. I don't think it's ever changed. Well, no, it changed once. It did go up a few years ago.
Well, let's extend for 3 years then.
I'd second that.
Okay. I pass the gavel. Do we have a vice chairman?
Okay, I have the gavel.
Aye.
Would you like to make a
I'll
motion?
make a motion to extend for 3 years.
Second.
All those in favor, say yes.
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 All those opposed? Passes unanimously.
Chair, can I ask just a question that would help us out if y'all would consider it before you go into G? Because you have finalized the tangible personal property but not the real estate, I have to certify the role, not just the tangible. So what in a sense this does is it makes the deadline for those property owners to disagree with their tangible values a different deadline for filing in circuit court than the real estate. What I'm asking you to do and consider is that readopting the tangible at the same time that you finalize the real estate, all it does is give those tangible folks more than 60 days if they disagree, rather than us have 2 separate deadlines for folks in the circuit court. Would you be amenable to that?
I don't see any issue with that, but we can just put it on the agenda for the next meeting. That's all that's really needed.
Thank you.
All right,
Makes it less confusing for property
and that
owners.
sounds great. Find that on the next agenda. So G, notifications to petitioners regarding request for reconsideration procedures.
So that was my request. You guys received an email from Mr. Thauser that kind of overviewed some of the, sentiments that we wanted to bring before the board. What I had asked, if you guys noticed, it's the notice regarding recommendation, the VAB timeline, it's the notices that go out to include, and if you look at some of the samples, it has the bold print and stuff like that on top of it. What I would like to do is two things. On this document, I was going to ask if it's okay if we actually put the dates in there, because under the current one, it just says 10 days, 15 days, but when these are issued, we know the dates. So remember the gentleman that came in and said, well, I thought this date and this date and all that, but if it says like a request for consideration must be received by the VAB clerk, in here it says 10 calendar days, I would like to try to put the date so that they know the date, that's all.
I think putting the date is a good idea, because then people are not gonna be confused as Saturday and Sunday count.
Yeah, right, and there's a little bit of, and it's not so much to say that, like, we're doing anything, it's just that the other piece is that it opens a door for people to argue a part that they may be not telling the truth and saying, oh, well, I didn't see it and all the other stuff, it just closes that door on them. But I wanted to ask you guys, when you're issuing those, is putting the actual date on there an issue, or we already know those dates, we already have those dates? Does that make sense?
On what? Put the date on what? Yes.
I'm sorry, I didn't know that you guys,
form
I
did you
apologize
want
if you guys didn't get the
it?
notice. Did you guys get Mr.?
On
this
that form, then, no, because that's a DOR form, and it's hard to alter that. Can we put it, we have to think about it.
So the DOR
We could put it
form,
on there.
so we're adding 10 days, all this other stuff, and bolding certain things. But what I'm hearing you say is we can't alter it to put the date in there?
On this form here,
Oh, no, ma'am, I'm
This is
sorry.
my memo.
The memo that he sent out had a couple of put in a couple of documents that, the notice for regarding recommended decision and reconsideration. Do you want to speak to that?
Yeah, this was adding some, I guess, extra explanations and information about the timeline of the whole VAB process and specifically request for reconsideration. It was the memo, it was attached to a memo I sent out.
that's fine. As long as it's not a DOR.
No, it's not a DOR.
Well, if I may, just because there seems to be a little bit, I want to verify that form that you guys see, you guys are okay with adding that date. And I want to make sure that we have those dates, because sometimes I've heard that we may not have the dates yet. I remember we were saying maybe we could set those dates out ahead of time so that everybody knows when these dates are, we can post them on the website and stuff like that. What I would like to do is, property appraiser mentioned earlier that the process of notification and all that stuff she feels could improve. We've heard from the attorney that they said could improve on websites and all that stuff. I would like to ask our clerk to review this to make sure that we can do that. And then also add part of the discussion at the next meeting to include what our property appraiser, along with the other individuals, had stated that we might need to add to, so website stuff and everything else. And I'll work on that and bring it back if that's okay with you guys?
Yes.
Okay. Yes, sir.
Jason Arthur, Chief Deputy with the Clerk's Office. My concern is, well, you're asking, I don't have the form in front of me, but what it seems like instead the form currently says 10 days from the decision or 15 days, whatever it says, you want the clerk to the board to actually put the actual date. That concerns me from the standpoint of errors if made on the part of the clerk to the board, if they were not able, miscalculated that date for some reason. I am not in favor of them actually adding dates to the form. If you want to make the form more clear to include, say it says 10 days, and put in parentheses next to it, including weekends, if that's what the concern is, whether it's business days, it says calendar days. If that's not clear enough for the public on the form, then add some wording that makes it clearer. I'm not in favor of the clerk to the board actually figuring out the number of days from the date of the final decision. I'd rather it be left up to the person who is using that form, filling out that form, to determine what those days are, make sure they're in compliance.
So what you're saying is that in order, you don't feel confident putting a date down on the form because the clerk might get it wrong, but we want to ask the actual tax owner to figure out based upon the rules. Is that,
That's what I heard.
that's what I'm hearing?
Yeah.
Yeah, I do not want that burden to be put on the clerk, to the board and staff. That's exactly.
But we put it on the public.
They are the ones that are filing that for the reconsideration. And it's incumbent upon them. If
Can
wanna
they call
file-
your office and say, this is the letter I just got, what would the date be? And then you give them an email that said, in your particular case, this is what this date would be?
I would have a problem with staff telling them that the date of the final decision was this day, and then let them calculate that out from there.
There is a degree of legal judgment in calculating dates. I know it seems like a very simple thing, that does cut both ways.
Do you include the day that expires as the day after it expires, or do you include when you start counting? It could be,
Agree, and I can understand how that's confusing to the public, and I understand where you're going, but I would rather clarify that, what you mean by 15 days or 10 days, whatever the number is on the form, and clarify that language to make it easier for the public versus putting the burden on the board staff to actually make that determination. As Mr. Baldwin, it does require some sort of legal
So you're saying,
determination, and we're ministerial.
so the issue is that it's where that 15-day line lands that they then determine based upon that, whether it's at the beginning, end, all that stuff.
sometimes it's not clear.
I see what you're saying. Can we work on that and bring it back and have conversations about, hear what you're saying?
Yeah, I mean, I'm all about Mr. Baldwin.
Dana, I see Dana has her hand up.
Would it be possible for us to get a copy of whatever your recommended changes are?
Absolutely. If we can forward that to them.
And I would ask, I'm sure Mr. Baldwin would review the language before anything is brought back to the board anyway. So, and if that language does not require the clerk to make some affirmative action, whether legal or not, then would not have an
So you
objection.
wouldn't have a problem putting the date that it occurred and then saying 15 days after this based upon this, this, and this?
No, the date that what occurred at the final.
So the date that starts the 15 or 10-day process, you wouldn't have a problem putting that date on and then 10
That's
days
already
from
on
here?
there.
That date's on
Okay.
there.
That's already on
Okay,
there.
gotcha, and then specifying it, okay.
So it says 15 days from this date.
Excluding holiday, weekends.
The date of the recommended decision is on the form. There's nothing telling you about the reconsideration process, giving you the days amount on this form. But the actual date that it was mailed out and emailed out is there for them. Like, we wouldn't have to necessarily provide that date because it's already on the form.
Instead of moving forward with some of this stuff, what I'd like to do is go back and look at it and then bring it back to the next meeting and hear what you're saying.
Yeah.
I think we're both trying to get to the same place.
Absolutely.
Can I approach like
Yeah, no problem.
So this is the date. They get the decision from the value adjustment office, and this is the date. This is the one that the special magistrate signs, and it could be sitting in a queue for a long time. So the top date is a different date.
Yep.
When the clerk sends it out, this is the date that we're going by, and that would be the 10 days from that date.
Okay.
And I believe in the request for reconsideration, it says, if it ends on a weekend or a holiday, then it goes
Yeah.
to the following Monday. So it would be the date after that.
Well, I appreciate
But
that.
there is a date on there, and that's the date that we go by when we say 10 days.
Right. Okay. Thank you. That's good. So the idea is to bring it back not only with recommendations based upon what we have here that are correct, that may alleviate some of the issues, but then also notices on websites and everything else that we have that are not here. I'll work diligently to get that taken care of before.
Okay.
If that's okay.
Yeah, it's great.
And I have something to add also. In the future, when we do mail out the recommended decisions, we are now going to mail out the request for consideration procedures as well, so that they will receive it, even though it's on the website, a few places. We will make sure we mail it to them as well, so that they are aware with each recommended decision.
Okay. Is that 10, 15 days? Can we extend that shortly? It's all statutory.
Yes, well, no, it's a local rule, but there's no discretion.
Okay.
It's a
Is
break
that
law.
under our rulemaking authority, or is that under another rule?
It's under the VAB's authority.
Okay, I just want to check. Okay, thank you, sir.
Okay, great. All right, that concludes G. I think we go to H, board reports from our attorney. No report. I have no report. Vice Chair?
I have a question. So, and this may be, Aaron, for you, it may be for Dana, I'm not sure. When the property appraiser makes a decision on appraisal of a property, they have particular categories. It has to be a like property and all of those things. Who determines what those are? Is that the state?
Appraisal standards and guidelines. Ultimately, it's I suppose, set by statute that they refer to privately determined appraisal standards.
So, like I said, I went through the process, and I believe that the way my property was valued, nobody violated any laws, nobody did anything wrong. But the issue is how and what rules they're using. How does that get looked at, challenged, discussed?
The standards themselves or the actual process for applying them?
The standards, I believe that they were applied correctly, but the standards themselves.
They're set by statute at the end of the day.
So
It's by the legislature.
Okay, thank you. That was just a question.
Those are good questions, very good. It's always good to have first-hand experience. That's why we have citizen representatives. Matt Susan.
Yeah, real quick, we had spoken before and you had mentioned that part of the process may be flawed, and you had given us a memo, which I reviewed from last year. If you can, make any recommendations that you've seen since then. If it's solid the way it is from last year, if you could resubmit that to our board so that we can take that into consideration when we do these next steps, as far as possibly changing some of those problems that we see.
The answer to you is yes, but no, in the respect that my concerns were spelled out in that memorandum from my attorney, because my concerns on noticing and the understanding of that and the threshold to be able to meet the standards of your local procedure and all, I believe makes this almost insurmountable without an attorney for the taxpayer. So whether or not, in my opinion, it's just my opinion, remember I'm the defendant in this quasi-judicial process, but my opinion is that it is a very top-sided process for those 3% of property owners that are not represented by attorneys or tax reps are going to be able to meet that threshold. What I would say is that we as the property appraiser and the property owner have to understand that when you come to a quasi-judicial hearing that we're going to defend our values and have the evidence that we use, the standards that we use, the statutes, references, all of that to defend our values, and they're going to have their evidence. And you are hiring state certified general appraisers and residential appraisers and attorneys to review these for you. So what I would say is, if you are having to have another local procedure because you are getting findings of facts and conclusions of law that are inconsistent, I would say go back to your magistrates and maybe ensure some additional training, or maybe have some sessions. I don't know what legally you can do with your current attorney. It's not going to be with us at least another 3 years, to your magistrates, rather than create another arduous process. You have everyone here today say to you, I don't even know how I meet this, to be able to have one. And clearly we have one, circumstances are horrible, but she wrote a one-sentence email. And so I think we as a citizenry are creating an additional insurmountable process for a property owner not represented by an attorney that they are not going to overcome. Okay, and unless you grant an exemption without an application in Ms. Grantland's case, I will have been successful, and now all of them. And that's not where I want to be. That's not the perception I want to have, and I don't think that's the perception that you want to have. This is supposed to be an informal exchange of information. We do our best to get information from property owners, like access to the property, information we can use to determine value, so we can come to a right consideration. I am not in favor of this additional rule. I think that you are finding now all of the caveats of DOR forms, but they don't recognize this procedure. So where do you add the date? Who decides what that date is? Who decides if you're going to accept it if it's a day late versus 12 days late? Are you going to apply the same standards to the other folks that applied for this process versus Ms. Grantland's, as horrible as her personal circumstances are. But folks, I get those hardship cases every day in my job. I get the widow that is now left with a property that she can't afford to live with. And nor can Ms. Grantland say, I'm gonna only accept 20% of your taxes because you have an inability to pay. Those are not things we have the discretion to do. So I feel like this is a great initiative by you. You're wanting to give the property owners another bite at the apple. And I understand that, but I think that the unintended consequences we are all now feeling as we sit here today. So I just don't have anything other to offer other than the legal pitfalls of that and the noticing requirements that I mentioned last year and this year.
I appreciate that, Ms. Buckley. I think where and I appreciate your long, arduous explanation of
And I
the other
apologize for
piece.
that.
That's okay. Where we are speaking to is the actual notification of the people that come before here, which seems to be a common theme among the people, understanding the dates and stuff like that. So when we've reviewed that, we felt like we could do a better job of our websites of all of those things. It wasn't to change the dates and all of those things. It was just to try to find out how can we legally notice our people and do a better job at that on our end as a VAB. And so are you saying that you would not submit that form from a year ago, or are you going, like I requested at the beginning of it, would you submit what you gave to us before but resubmit it to the board? Or would you like to update that because you had said what you said just now and previous to a new form, or would you like to submit the old one? I want to include what your concerns are in this as we move forward, that's all.
I can do that. I can put everything that I said last year and this year and memorialized in the legal memorandum to pen and paper, but I can tell you that it will be, if the property appraiser, and you understand you're asking the defendant to weigh in on the process, and that is a bit difficult for me. When there's a lawsuit in case, the defendant normally doesn't, nor the plaintiff, get a chance to tell the magistrates or the judge hearing the cases what they should do with their procedure. So I am tiptoeing around this, saying that I feel that you are creating, again, good initiative, but bad judgment, in that we're creating a process that is almost insurmountable for them, and it doesn't need to exist.
And I understand that.
It doesn't change due process, doesn't give them more rights. You can't review, if Aaron determines that findings of facts and conclusions of law are inconsistent, he absolutely has the authority to send that magistrate that decision back and say, this is incomplete.
And I appreciate that, Ms. Bickley. You are a part of this process, and I want to make sure that your concerns are heard and a part of it. So if there's something that we can do that might work in that, I want to make sure that we're not creating something that then becomes an issue with you. So if you could resubmit that, that'd be great. Thank you so much. Do we have a date that we need to set? You guys okay with, can you look at your calendars for the next meeting?
Looking at it.
I think we should move pretty quick too, because if there's, do you feel like there might be anything after that that needs to be before?
There should be.
So we're gonna send to the special magistrates, can come back, so our next day should be our final.
I would say the board could have a meeting as soon as a week,
You think you get to them by then?
Definitely.
Get them to review that?
unless they're away or something like that, yeah.
Aaron, can I just ask you, and again, I'm not the officer of the court here, you're weighing in on local procedures that have been adopted by the board, and you're allowing us to weigh in on them, and of course the ministerial arm. But does the public get to weigh in on whether or not they find, because I think if you're going to be accepting recommendations on a local rule that it's your policy, it's not DOR policy, it's not state law, it's not in the rules and regs. Should you have a public hearing that says we have a local procedure here and we are looking for input from the public to weigh in on this? Is it arduous for you, public? What are the pitfalls for you, public? I would feel much more comfortable if I'm going to be weighing in. I feel like that the property owners, and granted, I understand the Pandora's box because the tax reps are certainly going to weigh in as well, but
No, I think, I hear you what you're saying. My goal was to meet with, because we have a short notice, and setting up a town hall and all that stuff would be great. I think my goal was to meet with the individuals that have come before this, their painstaking process of what they feel. So identify probably 10 or 15 of the people that have applied, go through each one of these, make sure that we find, I'm gonna call that attorney, make sure that they're in, and then make a recommendation based on that. I like that. Maybe that's what the next VAB will do next year. Good example. I think right now, because of the short amount of time that we have to make these changes and stuff, I'd like to try to work diligently to try to complete that. But great suggestion.
My schedule's a little bit crazy next week,
Okay.
but the 20th and the 22nd, I could make work, and probably the 23rd. So for me, the 20th, 22nd, or 23rd would be,
Okay. The 20th, 22nd, or the 23rd. I've got, that 22nd looks good for me. Same time.
That's for me.
22nd is best for you.
What about you?
I can only do the 20th or the afternoon of the 22nd.
22nd?
Works for me, the afternoon, 22nd, works for me.
My afternoon's
Whatever you
good.
need.
You guys are?
What?
Yes, sir.
22nd.
Yeah.
What time?
Really, any time in the afternoon is fine with me.
Let's say one.
Noon and afternoon.
Let's say 1.
What the date?
22nd at 1 o'clock. Thank you, everybody, I appreciate that.
I guess none of you are celebrating Earth Day.
Yeah,
Celebrating here.
exciting way to celebrate.
I'll bring the blue trees.
We'll go put some trees out.
I was using the trees.
That changes the value, you know?
Careful. Did we ask the clerk if that works for them?
Yeah, that's what I was saying. Does that work for you guys as far as?
I have no idea. It'll work. We'll make it work. Somebody will be here.
Right. So 1 o'clock looks good for me. You guys?
She's calling the switchboard to see if there's anyone available.
Okay. We can always meet over at the school board if we need to, too. That'd be fun. Yes, come over and hang out with us. Plenty of rooms over there. And we like public comment.
My agenda later. Oh, we're still on board reports. Matt, was that your board report?
That was my board
Okay,
report.
okay, all right.
All right, good. All right, Robert Springer.
I have nothing, sir.
All right, Rob Adams.
I'm good, thank you.
Oh, good, that concludes our board, our reports, and I think that concludes the agenda. Meeting.
Thank you.
Thank you.
Gentlemen.
Thank you. We adjourn.